So it is my pleasure to introduce the first panel of the day, which is entitled Disappearing and Reappearing, Refugees Between NGOs, Legal Status, and Return. The panel will be moderated by Professor Susan Akram. Susan Akram is clinical professor at Boston University School of Law, teaching immigration law, comparative refugee law, and international human rights law, and supervising students handling refugee and asylum cases in BU's Asylum and Human Rights program. She's a graduate of the University of Michigan, Ann Arbor, Georgetown University Law Center, Washington, D.C., and the Institut International des Droits de l'Homme, Strasbourg. Before joining the faculty at BUSL in 1993, Susan Akram was executive director of Boston's Political Asylum Immigration Representation Project, and before that, directing attorney of the Immigration Project at the public interest law firm of Public Counsel in Los Angeles. She is a past Fulbright Senior Scholar in Palestine, teaching at Al-Quds University, Palestine School of Law in East Jerusalem, and researching on durable solutions for Palestinian refugees. She was also interim director of the program for resettling Iraqi refugees from the camps in Saudi Arabia after the first Gulf War. She has spoken and published widely in the fields of immigration law, refugee law, and human rights. Our two panelists will be Irfan and Jinan Bastaki. And Irfan will be presenting a paper entitled Handing Back the Keys, UNRWA and the Right of Return. And Irfan has a long-running interest in the Middle East in general and Palestine in particular. She studied Middle Eastern history as an undergraduate at Oxford and then obtained a dual master's degree in the subject from Columbia University and the London School of Economics. For her master's thesis, she investigated the evolving relationships between the Palestinian refugee camps and the UN after the '67 war, researching this topic at UNRWA's closed archives in Amman. Outside of academia, Anne has twice volunteered with the charity Unipal, teaching English in the West Bank. Having completed an internship at the New York office of the UN Relief and Works Agency for Palestinian Refugees, UNRWA, she now works for the London-based NGO Medical Aid for Palestinians, which provides services in the West Bank, Gaza, and Lebanon. Jinan Bastaki, meanwhile, will be presenting a paper entitled Disappearing Refugees and the Legal Gaps, the implications of third country citizenship for Palestinian refugees and the right of return. Jinan Bastaki is a law graduate of the London School of Economics and UC Berkeley, with a particular focus on international law, refugees, and the use of force. Currently, she is a PhD candidate at the School of Oriental and African Studies in the Law Department. Her research focuses on Palestinian legal consciousness and the right of return for the diaspora. Please join me in welcoming them.
Okay, good morning, everyone. I'm just going to move this because I'm shorter than you boys. So, I'd like to thank the committee for inviting me to speak today, and I'd like to thank all of you for turning up so early on a Sunday. Luckily, I'm on British time, so it's 3 p.m. for me. Jet lag has some advantages. Now, we heard a lot yesterday about the really important matter of creating the necessary discursive and paradigmatic shifts so that we can create a practical model for return. Now, at risk of abandoning my own post-colonialist convictions, I'm going to take more of a top-down approach today and look at how we can create an appropriate institutional framework in which we can implement return. So it goes without saying that any effective implementation of return will require the cooperation and the engagement of all the major actors. This means not only the key states and the institutions in civil society, but also international organizations, most obviously the UN. The UN has, of course, been present in the Palestinian refugee crisis ever since 1947, when General Assembly Resolution 181 recommended the partition of Palestine and gave the Zionist movement a green light to go on and establish a state. In the 66 years since then, the UN has occupied a constant presence within the Palestinian question. It's rarely driven events, but it's often provided legitimacy or criticism after the event. And as we all know, the UN has frequently been accused of bias, usually biased towards the Palestinians when it comes to the General Assembly and biased towards Israel when it comes to the Security Council. Yet, although it's these two bodies, the General Assembly and the Security Council, that tend to receive the most attention in these discussions, there is another UN body that I want to focus on today. This is the UN Relief and Works Agency for Palestine Refugees in the Near East, or to use a catchier title, its acronym, UNRWA. We heard some references to it yesterday. I'm going to focus on it in more detail today. UNRWA has been responsible for the welfare of the Palestinian refugees ever since it began operations in 1950. Today, it's the main source of shelter, healthcare, and education for around 4.6 million registered Palestinian refugees across the West Bank, Gaza, Jordan, Lebanon, and Syria. UNRWA's official status as a non-political agency means that it is often ignored in discussions about return, which of course is deemed a very politicized issue. Commissioner Generals of the agency across the years have repeatedly reiterated that the agency is a humanitarian agency alone. Its role is simply to provide services to the refugees, and it's nothing to do with politics. Yet, I would argue that UNRWA's constant presence, its breadth and depth of knowledge about the refugees' history and situation, and its quasi-governmental status in some of the camps make it a vital part of any successful resolution of the refugees' plight. In fact, as an officially non-political body preoccupied with humanitarian concerns, I would argue UNRWA is particularly well placed for a discussion about the practical elements of how we can bring about return. UNRWA has a vital part to play in resolving key issues such as who is a refugee, how can this be proven, how can return be implemented, and how might the post-return state of Palestine look. So today I'm going to look at UNRWA's broad-based significance within this issue, the challenges of involving it, and the implications for the agency itself of implementing return. There are some key questions to be explored. How can UNRWA either directly or indirectly help make the case for return without breaching the terms of its own mandate? Why is its inclusion so crucial? What might be the disadvantages of making UNRWA part of the discussion? And what would or should happen to UNRWA itself after return is implemented? Ultimately, I contend that any move to implement return needs to acknowledge UNRWA in order to be truly comprehensive. And to demonstrate why this is, I'm going to look at three crucial characteristics of the agency's work. These are, firstly, its activities in the field of protection, secondly, its records, and third, its potentially representative nature. So, to take each one in turn, UNRWA's activities in the field of protection is a topic that comes with considerable baggage and is the subject of a very major academic debate that I'm only going to summarize here to illuminate the agency's legal position. Now, according to the terms of its establishment, UNRWA is not mandated to pursue political solutions to the Palestinian refugee crisis. This instead is the role of another body, the UN Conciliation Committee for Palestine, or UNCCP, which was established in 1948, but in practice has really been inactive for decades. Its mandate has never been terminated, but it's not really an active organization. The General Assembly resolution that established UNRWA actually directed the agency to consult with UNCCP on their respective tasks, but this is rather an academic point, given that the UNCCP does not really do anything. So the Palestinians are uniquely and explicitly excluded from the mandate of the UN High Commissioner for Refugees, which serves all other groups of refugees. General Assembly Resolution 428, which established UNHCR, actually states that its competence, quote, shall not extend to a person who continues to receive protection or assistance from other agencies of the UN, i.e. the Palestinians. So this setup has led numerous scholars, including Randa Farrar and our moderator, Susan Akram, to argue that there is a protection gap in the services available to the Palestinian refugees, that they are left uniquely vulnerable among refugees in the world. The contention is that UNRWA's activities in the field of protection are insufficient compared to those of UNHCR, and the comparison is made more pertinent by the fact that, unlike UNRWA, UNHCR explicitly endorses and even promotes return as the preferred solution for refugees. Now, UNRWA staff themselves have taken some issue with this, and they argue that actually the agency does undertake protection activities. So Lance Bartholomew, who's the chief of UNRWA's International Law Division, writes that the agency has a clear mandate for protection, which he defines as all activities aimed at obtaining full respect for the rights of the individual. Similarly, Karen Abu Zaid, who was Commissioner General of UNRWA from 2005 to 2010, characterized the agency as a global advocate for the protection of Palestine refugees, and she appointed a senior protection policy advisor to underline this point. So there's a bit of a debate we see here between these two camps. We can find some synthesis through the work of another scholar. I promise this is the last scholarly name I'm going to throw at you, Michael Kagan. He draws a very important distinction between exactly what we mean by protection, what the possible different definitions of it are. So on the one hand, he talks about protection in the sense of finding a just and durable solution to the refugee crisis. But there's also protection that can be provided through welfare services. And while Kagan agrees that UNRWA does not really push for a just and durable solution, he thinks it does play an active role in providing protection through its welfare services, in recording abuses of Palestinian rights, intervening and communicating with governments when necessary. The general consensus is that this has been a major characteristic of UNRWA's activities, particularly in the West Bank and Gaza, since the First Intifada. Actually, during my own research at UNRWA's archives in Amman, I found evidence that it really reached back, at least in the West Bank and Gaza, to 1967 and the onset of the Israeli occupation of those areas. And in other fields, particularly Lebanon, it did reach back even to the 1970s. So the point is that UNRWA has actually undertaken protection activities in some way, maybe not sufficiently. Now, bringing all of this back to the main point that we're discussing today, this is important because we can see that providing protection in this way through general welfare is consistent with UNRWA's mandate. So there's a basis on which UNRWA could aid the implementation of return without breaching the terms of its mandate. It can't lead a campaign for the implementation of return, and we wouldn't want it to, but it can be involved in the process. And I will now elaborate on exactly how by looking at UNRWA's importance in terms of its records and then its potential representative role. Now, as we heard from Dr. Abu Sitta yesterday, one objection to implementing return has been the claim that the Palestinians are dispersed, we don't know where they are, how are we going to make this happen? Now, obviously that's wrong for a lot of reasons. I'm not going to go into all of them here. But when we're responding to that criticism, UNRWA can play quite an important role. Actually, UNRWA's records lie at the heart of its importance in this respect. UNRWA is the only organization in the world that has continuously collected and maintained data about the Palestinian refugees since the Nakba. It was created the year after the Nakba. It began operations in 1950, and it's still operating today. So its records last nearly the whole span of the Palestinian exile. And although financial limitations mean that UNRWA only serves the neediest Palestinian refugees today, its records continue to document the previous registration of many others. And that means they can be crucial in resolving the practical issue of who the refugees are and who is entitled to return to Palestine. Now, it's important to note that UNRWA's records of Palestinian refugees are not fully comprehensive. The agency's definition of who constitutes a Palestinian refugee was developed with operational rather than legal considerations in mind. So it counts as a Palestinian refugee, quote, a person whose normal residence was Palestine for a minimum of 2 years preceding the outbreak of the conflict in 1948, and who, as a result of this conflict, lost both his home and his means of livelihood. This actually differs from General Assembly Resolution 194, which called for the implementation of return for all refugees who wish to return to their homes. There was no reference to whether or not they'd lost their means of livelihood. In 1982, the General Assembly actually did ask UNRWA to issue ID cards to all Palestinian refugees who had lost their homes in 1948, regardless of whether they'd lost their livelihoods and regardless even of whether the agency provided them with services. The idea was to create a full registry of Palestinian refugees, which obviously would have been invaluable, but resistance from the Arab host governments in which UNRWA operates rendered this impossible. So UNRWA's records do not and have never included the entire population of displaced Palestinians. It's estimated that the Palestinians registered with UNRWA constitute around 2/3 of the total number, maybe slightly less. But what's significant is that UNRWA's definition of a Palestinian refugee does still encapsulate large numbers. The extension of its criteria to include descendants of the Nakba generation means that there are 4.6 million refugees registered with UNRWA today. And actually, contrary to what is often believed, the majority of these registered refugees do not live in the camps. Somewhere between 20 and 30% of UNRWA registered refugees are camp residents. So UNRWA's records can't constitute the sole source of information on who counts as a Palestinian refugee, but they can go a long way to at least beginning to answer the question and easing the potential bureaucratic nightmare of how do we implement return. And used in tandem with the deeds, the papers, the municipal records that are retained by many Palestinians to this day, UNRWA records could provide strong evidence for the rights of those wishing to claim return or possibly wishing to claim compensation instead, in some cases. Furthermore, UNRWA's own deteriorating state underlines the already compelling practical case for why return needs to be implemented as soon as possible. The agency which is responsible for the welfare of the neediest refugees is currently facing a deficit of $71 million. And this is nothing new. It started every year for the last 3 decades with a large projected deficit. The last time I could find in its records that all core programs were funded was in 1986. Today, the situation is so bad financially that UNRWA can't even afford to cover its core activities, let alone anything else. It actually, last year, had to create a new category of poverty, which was really meaningless because the level was so low anyway, in order to reduce its services further, because the financial situation is so limited. So in other words, its operations aren't sustainable, and its ever-worsening financial state really reinforces the case for the refugees' plight to be resolved as soon as possible. This is obviously a supplementary point. This is not the reason that return needs to happen, but it is still significant in practical terms. And actually, this financial case for implementing return may be particularly compelling for those states who are funding UNRWA, i.e. the US and the EU, particularly given that there's a lot of controversy over them funding UNRWA at all. This, however, is not the end of UNRWA's significance to this issue. In fact, perhaps ironically, one consequence of the agency restricting its services to only the neediest refugees in recent years has been the potential enhancement of its representative role. It serves the poorest and the most vulnerable Palestinian refugees, which means that its understanding of the situation is drawn from the most marginalized Palestinian voices, who are usually too often excluded from the high-level diplomatic negotiations. UNRWA must never be used as a replacement for engaging directly with the refugees themselves. But its inclusion is important for ensuring that the fundamental humanitarian needs of those most vulnerable are not forgotten. This is especially pertinent if we consider that around actually 99% of UNRWA employees are themselves Palestinian refugees. They do tend to be concentrated, surprise, surprise, at the lower levels of the agency's hierarchy. But including these voices in relevant discussions over return, rather than limiting the representation to senior management, could reinforce UNRWA's power as a representative. So, we've seen some of the ways in which UNRWA's inclusion could aid the practicalities of implementing return. And given the major task that we have at hand to bring about, these advantages should not be dismissed lightly. But this is not to say that incorporating the agency into the process will be entirely free of problems. And if we're going to really consider this effectively, we need to also assess what the challenges might be. Now, there are several, and because of time constraints, I'm only going to mention a couple. One, for example, is the agency's own limitations. It's answerable to the UN General Assembly. It has limited autonomy, although it does have some. Its operations are restricted to the 5 fields: West Bank, Gaza, Jordan, Lebanon, and Syria. It doesn't serve all Palestinian refugees. And this really needs to be continually emphasized to avoid the risk of excluding unregistered refugees from the process of return. We really need to stress that it's only representing some and not all of the refugees, and that this is not the final criteria on who is a refugee. There are also problems in terms of how the agency is perceived. It's been the subject of long-running suspicions from all sides. So it's been characterized as the handmaiden of the anti-Zionist Third Worldist General Assembly and inherently biased against Israel. Actually, last year, the Middle East Quarterly Journal ran a special edition on UNRWA, containing about 10 articles, all condemning it as prejudiced against Israel, self-serving, and inappropriately politicized. The Canadian government cut its funding to UNRWA in 2010, citing concerns over its lack of objectivity, apparently. And inversely, some Palestinian refugees have seen UNRWA as part of an international support structure for Israel, funded by the US, and designed to prevent the realization of return. So involving UNRWA in implementing return does risk importing these disputes into an arena that's so heavily beset by conflict already. Care must be taken to emphasize that the purpose of its inclusion is practical and not political. It's supplementary. And it's crucial to ensure that the agency behaves broadly in accordance with its humanitarian mandate and remains focused on the practicalities. Now, finally, there's a question mark over what would happen to UNRWA itself after the right of return is implemented. Although it's been around for 63 years, it's actually still a temporary agency. Its mandate is renewed roughly every 3 years, last time 2011. So we could assume that we're simply going to dissolve UNRWA once return's implemented, it will cease to exist. But it's not inconceivable that it could continue to provide limited relief services where necessary while the situation stabilized. As a humanitarian relief organization, UNRWA would be well placed to take on this role, making use of its considerable infrastructure to aid the housing, the healthcare, the education of the refugees turned returnees. And as the returnees sought to establish their new lives, it would be feasible and appropriate for UNRWA to hand over full control of the transportable parts of this infrastructure, particularly the school and the health systems. Citizens of the new state can adapt and modify and integrate these systems as they desire. And such a handover has the potential to relieve socioeconomic tensions by minimizing the upheavals that return is inevitably going to bring. While it may be necessary to modify the agency's mandate to allow for this, such modification is really not an insurmountable challenge. In fact, a model already exists for it. The agency previously moved to modify its operations in the West Bank and Gaza after what I'm sure we'll all agree was the raging success of Oslo in 1993 and the establishment of the PA. The year after this, the Commissioner General at the time said that the agency would be dissolved in the West Bank and Gaza within 5 years, and that all of its functions would be handed over to the PA. The agency even then launched what was called Peace Implementation Program, which was designed to help the PA build up its infrastructure. And there were discussions about integrating the refugee camps, at least in the West Bank and Gaza, into neighboring municipalities in order to establish Palestine as a fully fledged state. Now, this designation of a 5-year period was, of course, in accordance with what was supposed to be the interim nature of the PA, and in practice, we all know things took a very different turn. I'm certainly not citing Oslo as a positive event within Palestinian history, but as a sign that the possibility of handover from UNRWA to the Palestinian people can be and has been envisaged with a view to ultimately resolving the situation. Moreover, UNRWA's arguably political move in endorsing and supporting the PA suggests the possibility of similar agency support for establishing a post-return state, in spite of the possibility of potential tensions over the terms of its mandate. It was a UN resolution that created Israel and facilitated the Nakba in 1948. As has been shown by the PA's recent moves for statehood at both the Security Council and the General Assembly, the UN's potential power in the course of events in the region has not died. It's therefore entirely appropriate that any implementation of return, the issue at the heart of the Palestinian cause, should include a UN agency. UNRWA's longevity, expertise, and symbolic significance make it by far the most suitable organization to take on this role, and to do so while keeping the refugees at the heart of the equation. Those trying to bring about the implementation of return do neglect the agency at their own risk. And given the high stakes already involved, it is not a risk that should be taken lightly. Thank you.
Hello, everyone hear me? Okay. Can everyone hear me? Yes, okay, cool. Okay, so as our MC said, my paper is titled Disappearing Refugees and the Legal Gaps, the Implications of Third Country Citizenship for Palestinian Refugees and the Right of Return. So I started writing this paper because as I was sort of researching the right of return for Palestinians, those who seemed to be most absent from the debate were those Palestinians with third country citizenship. And looking into it a little bit more, just refugee law in general seemed to include those who obtained citizenship from sort of refugee rights and things that are contained sort of that are assumed that only a refugee has. And once a person gets citizenship, those rights, that person has the protection of a state. And so I started actually interviewing also Palestinians who had third country citizenship. And it was interesting to sort of see their responses and also explore Palestinian legal consciousness, so how they felt the law affected them and what they perceived the law to be in terms of their rights. So there were three sort of like main issues that came up. And so firstly, as I said, recognized refugee status gives sort of rights that are well established in legal conventions and customary international law. And most importantly for Palestinians is obviously repatriation, the right of return. But refugee law in general sort of excludes those with third country citizenship. So my question is the right of return necessarily tied to refugee status or recognized under sort of a recognized definition? And also, how is legal consciousness, so the Palestinians with third country citizenship, how they perceive their rights, is that helping or hindering the cause? So firstly, I want to start out with a little bit of legal history. There might be some overlap because of the subject with Anne's paper. So some legal history. So prior to the 1951 convention relating to the status of refugees, which is now considered sort of the most, you could say, universal definition of who or what a refugee is, refugee groups were sort of dealt with on a case-by-case basis. So for example, you had in 1938 a specific convention dealing with German refugees and outlining what should happen with them and who's qualified to be considered a German refugee. But the 1951 convention was sort of formulated for European refugees because it was dealing with the crisis at the time. And it was individualized, so it was aimed at sort of protecting refugees and not simply providing temporary relief. In 1967, the 1967 protocol removed any of the geographical and temporal limitations, and that's when it sort of became universalized. And so there was, at the similar time, a separate regime for Palestinians. So there were, as Anne said, two agencies that were created, UNRWA, which was to provide relief for the Palestinians, and it was regarded as something temporary, and the UNCCP, which was tasked with this, the protective function, so actually searching for durable solutions, ensuring that the Palestinians would be able to go back home. But obviously, after many failed attempts at negotiating with the Israelis and the international community, its role was reduced to gathering information on refugee property by 1952. So who is a refugee? According to the 1951 Convention relating to the status of refugees, it's a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside his country of nationality and is unable, or owing to such fear, unwilling to avail himself of the protection of that country. And so this is sort of, and again, I mean, even with this itself, there are problems. Not everybody fits into this definition, not just Palestinian refugees. Now, for Palestinian refugees, even though we have these two agencies that are tasked with, relief and protection, there's no uniform definition. So UN General Assembly Resolution 194 says the refugees who wishing to return to their homes and live at peace with their neighbors, doesn't really define who those refugees are, but I guess it's assumed, obviously, the people who were expelled. And then we have UNRWA's definition, and obviously it was formulated for purposes of aid. So who's going to qualify for aid because of donors? And so people whose normal place of residence was Palestine between June 1946 and May 1948, who lost both their homes and means of livelihood as a result of the 1948 Arab-Israeli conflict. So, and there were also many people who didn't even register with UNRWA. So, and there's no specific rights that are attached to refugeehood except what's outlined in UN General Assembly Assembly Resolution 194. So as we can see, there's a lot of gaps. So first, the Refugee Convention itself is formulated for a particular kind of refugee, and now it applies to everyone. And then in Article 1D of this convention, it specifically excludes Palestinian refugees by stating that those people who are receiving, who are present receiving sort of aid from organs or agencies of the UN are excluded. It includes them if the UNRWA function sort of ceases or they're outside of UNRWA area of operations. But unfortunately, this has been interpreted in different ways according to different sort of national or domestic courts. And then you also have the issue of the 1967 refugees, and they're not even called refugees, they're called displaced of 1967. There's a specific UN resolution related to them, UN Resolution 237, which calls to facilitate the return of those inhabitants who have fled the area since the outbreak of hostilities. But unfortunately for them, many of them, because the West Bank was annexed by Jordan, they had Jordanian citizenship. And so even the fact that they fled and that they were, at least for theoretical reasons, you can say they are refugees. They fled their homes. They weren't allowed to return. They fled because of war. Their issue was not seen as immediate or as of a pressing concern because they had the protection of a state. And so refugee law, as we know, it advocates for three solutions: repatriation, local integration, and third country resettlement. And so if third country resettlement is seen as a solution, does that mean that rights to any other solutions are disappeared, or are they sort of relinquished, or do people give them up? And so I argue here that refugee status is not a necessary prerequisite for the right of return. Because if we look at, for example, those conventions that deal with the right of return, for example, the Universal Declaration of Human Rights in Article 13, it affirms the right of everyone to leave any country, including his own, and to return to that country. And so there's no, obviously, mention of refugees. Israel is a signatory to the International Convention on Civil and Political Rights, which states in Article 12 that no one shall be arbitrarily deprived of the right to enter his own country. Again, no person, not necessarily attached to refugee status. And what's interesting is when speaking about the right of return, in a particular context in Bosnia, the UNHCR cited the context of the conflict there. So it says, since widespread ethnic displacement was a central objective of the conflict in Bosnia, the right of refugees to return to their pre-conflict residence is essential to effective peace building. So it's important that when we talk about the right of return, it's not sort of to say, well, this is your solution, third country citizenship, and now you're done, you don't get the right of return. You have to look at the context in which these refugees actually fled. And so another area in which sort of the right of return can be advocated is actually state responsibility. And so under state responsibility, Israel is obligated to remedy its violations of international law. And as we know, there are many violations of international law. And so, for example, like under the laws of state succession, which is in customary international law and the international law commission's draft articles on state succession, a state cannot arbitrarily denationalize people. And so a lot of obviously the Palestinians who were the inhabitants of the land were under the British mandate. Many had British mandate passports. And so these people were collectively denationalized. And Israel obviously has to remedy this violation of international law. Another thing, states have a duty not to expel, and this is a duty owed to its neighbors because then they have to receive those refugees. And so this is, again, under customary international law. And also states have a duty under the Geneva Conventions not to transfer the civilian population. And we know, as we know, the ethnic cleansing is ongoing. House demolitions, the wall, confiscating, for example, residents of East Jerusalem, their IDs. So it's continuously making refugees, but under international law, there seems to be this gap where they don't fit into a particular definition, or because they happen to have a third country citizenship, their rights of return are not spoken of. But if we look at sort of the state responsibility, just obligating Israel to remedy its violations of international law almost would naturally allow these people who were expelled to return, in my opinion. And so finally, I come to this issue of legal consciousness, because it's interesting to look at literature and how sort of there's so many Palestinians in the diaspora, and they're Palestinians living in the, in the United States, and obviously Jordan and the UK and Western Europe and basically all over the world, and yet nobody really speaks of the rights of those Palestinians to return. And I thought it would be interesting to interview Palestinians and to ask them what they thought their rights were with regards to the homeland. And so I interviewed a couple, about 32 Palestinians who have US citizenship. And I just wanted to read sort of some quotes. And for me, what was important was to gather, obviously, the oral history to show that there wasn't a difference with how they fled, that it was forced displacement. And just because it's obviously assumed that it's a more privileged position, you have a protection of a state, you're not living in a refugee camp, you're not stateless, but still the origins and the reason why you have the citizenship of a third country is this forced displacement. So one of the people I interviewed, and she's living actually in the Bay Area, and so she said, I was born in Gaza and stayed there until I was 5 years old, but because of the 1956 war, we had to go back to our original village 5 miles away from Jerusalem. We went to live in the village called Beit Iksa. We lived there until 1967. Because of the war, we had to leave again to Jordan. They called us an-Nazihin, which means the displaced people. We were afraid that the same thing would happen as it did in Deir Yassin, the rapes and the massacres. So we went to the nearest place, which was Jordan. I finished my high school in Jordan. After that, I got married and I went to Saudi Arabia. We lived there for 10 years, and then we had to leave again in 1978 and came to America. And this person, what was interesting was because she left after the 67 war, and she got married in Jordan, her sister was able to go back to their village in Palestine through the family reunification, the Lam Shamal, but she wasn't, because now she was regarded as part of her husband's family, and so she could never actually reunite with her family. So there's obviously like a gender dimension to even the right of return. And then when asking sort of, those in diaspora, do you believe that you do have a right of return? I'm also going to read just some quotes because some things are very interesting. So this person, he says they because he's actually from 48 and he has Israeli and US citizenship. And he says, I think they should have a right to return regardless. The only reason they left is because they had to. It's not because they chose to leave or anything like that. Why don't they put it up for debate? Whoever wants to go home, whoever doesn't want to go home, he can stay where he is. And that solution that they're talking about, third country resettlement, insurance companies down here in the US, if your house burns down, the first thing they do is give you $10,000 just so you can survive for the next whatever. And then you're guaranteed your house. You're guaranteed to go back home. So those solutions are supposed to be like that. They're supposed to guarantee us a means to live until we're able to go back home. These are not solutions, third country settlement. The solution is to go back home. And another person also, he's an older gentleman, and he said, I think that the right to return to a person's homeland and their center of epistemology should not be governed by any external regulations, regardless of which way the person left that area. I think that's a principle. And ironically enough, if we think of the state of Israel, they have a right of return that is not contingent on any condition, refugee or otherwise. But yet the indigenous population of Palestine that has been expelled have to actually go through the hoops, to go through the United Nations agencies that deals with refugees, which actually created the problem to begin with. And so some observations on these interviews, and so most of the respondents felt that they had an inherent and a moral right of return, but an uncertainty whether the law affords them such a right. And so this was important because a lot of times if you speak to Palestinians who are stateless, Palestinians who are UNRWA, registered refugees, there's always reference to law. There's always reference to the principle of the right of return, to Resolution 194, and to all the sort of General Assembly resolutions that are dealing with Palestinians. But in this case, there wasn't really any reference to the law. And also there seemed to be some almost guilt in having citizenship. One respondent actually said, even though I had no choice in leaving, I had to leave, and she was one of the people who had to leave after 67. She said, I feel that those who stayed are better than us. They actually stayed and we left. Even though, obviously it was forced displacement, they were expelled from their home, but there was almost this guilt in having citizenship in another country and being, quote unquote, comfortable. And so And so this, for me, sort of explains a little bit of why the Palestinians with third country citizenship are sometimes excluded from the debate and from the discussion on the right of return, and why there doesn't seem to be any concrete sort of rights in the law that speak about people who were ethnically cleansed or people who were expelled, who were displaced, who are not considered refugees according to any legal definition, but still have a right of return because of the way in which that they left their home. And so just to conclude, so as I said, my argument is that the right of return is not necessarily linked to refugee status, but they are also attached to the remedies due to Israel's violations of international law. And this is, I think, really important. And also context must be taken into account when discussing solutions for refugees and the right of return, and not to sort of put a blanket solution. Number one is repatriation. If we can't do that, then local country integration, and then something else, and you lose your rights to any other solution that there may have been. And also, Palestinian legal consciousness in the diaspora generally seems uncertain as to whether the right of return applies to them. And I feel that this should be developed, and there should be a discourse for the right of return for all Palestinians, whether they are recognized in the law to be refugees or whether they have third country citizenship, but they were expelled or their parents were expelled. Thank you very much.
Good morning, everyone. It was hard to turn down this invitation since my office is about a half dozen steps from here. So I couldn't think up a reason not to be here, but I'm very happy to be here, frankly. So thank you to Anne and Jinan for their insightful presentations. And since I didn't submit a paper, I want to confine myself to a few remarks to support a couple of points raised by Anne and Jinan, and also to be responsive to some of the issues that were raised yesterday, and then to be provocative, examine these issues from the international law perspective and tie them into a proposal for a small step forward. So Anne has raised the point about the key role that UNRWA can play in facilitating durable solutions for Palestinian refugees. Jinan has focused on return as an intergenerational commitment by Palestinians to their homeland. My presentation takes these as points of departure to propose a renewed effort for, and I will listen to your laughter, Birthright Palestine program, focusing on what aspects of such a proposal are consistent or inconsistent with international law. I want to make 3 points here. First, that a Birthright Palestine proposal can be interpreted as recognizing the national tie of Palestinians to their homeland. Second, that there is no parallel between Birthright Palestine and Birthright Israel from the international law point of view. And third, that Birthright Palestine as a civil society action does not create or negate, but furthers the right of Palestinians as refugees or as nationals to return to their homes or place of origin. I will end with a proposal to modify the current notions of Birthright Palestine and the long-standing Birthright Israel for both to be fully consistent with international law. How do Anne and Jinan's theses relate to a Birthright Palestine? There are 2 particularly important rights that are fundamental to the proposal and are departure points for Anne and Jinan's work: the right to a nationality and the right to return to place of origin. As to the first, Palestinian nationality has been recognized at an international level since the Treaty of Lausanne of August 1924. And incorporated as a matter of domestic law in Palestine through the Palestine Citizenship Order of 1925. The Israeli law repealing the Palestine Citizenship Law and replacing it with one that denationalized the vast majority of Palestinians in 1950 recognized Palestinian nationality. And the denaturalization of the Palestinians was an illegal act as a matter of international law. That is so because it violated 2 fundamental customary law principles. First, that all habitual residents of the territory of a state which succeeds another must be granted citizenship in the new state, and that no state can arbitrarily denationalize habitual residents of its state on the basis of protected grounds, such as race, religion, ethnic, or national origin. If Palestinian nationality remained intact from 1924 because Israel's denationalization was void from an international law perspective, then all Palestinians recognized under that nationality law and their descendants have the right to claim nationality tied to the territory covered by British mandate dating back to the time of such recognition. As to the second right, Palestinian refugees and Palestinians claiming nationality dating from 1924 and through subsequent generations have an absolute right to return to their place of origin. The right of return of refugees, persons displaced by conflict, and nationals of territory is a customary right that was well recognized and implemented by 1948, grounded on multiple sources of international law. Refugees always have a right to return to place of origin after displacement. There's no distinction between forcible or non-forcible displacement in guaranteeing persons fleeing conflict their right of return to their homes. State practice on individual return or organized repatriations was entrenched in every part of the globe long before the first treaties incorporated these principles. And without serious question about the underlying right of the individual returnee. Without going into a detailed analysis about the legal provisions, it is safe to say that the universal instruments grant a habitual resident of territory the right to return to his or her precise place of origin, his home, regardless of current nationality or citizenship status. Moreover, these instruments make no distinction between individual or mass return. Israel is a party to all the major treaties that ground the right of return: the Fourth Geneva Convention, the International Convention on Civil and Political Rights, the International Convention on the Elimination of Racial Discrimination. Israel's massive denationalization of Palestinian Arabs on the basis of their national or ethnic origin was a violation of law at the time it occurred, and Israel remains bound today, despite the long passage of time, to remedy the denationalization and expulsion by implementing the right of return. UN General Assembly and UN Security Council resolutions over decades affirm and reaffirm the right of refugees to return to their homes in every part of the world. In every part of the globe, the right of refugees to return to their homes and lands of origin is incorporated in peace treaties, implemented individually or through mass repatriation, and recognized by states. In fact, the right of refugees to return is one of the most, if not the most, widely implemented and recognized rights that exists in human rights law. Taking only one decade as an example, the 1990s, an estimated 12 million refugees repatriated to every region in the world. In contrast, only 1.3 million refugees were resettled during that decade. UNHCR itself calculates that today less than 1% of the world's refugees are resettled. The overwhelming majority is repatriated or returned post-conflict. From state and international practice alone, it is evident that under international law, refugee return is the rule, and non-recognition of Palestinian refugees' right of return is the aberration. My second main point is that there is no legal parallel between birthright Palestine and birthright Israel. So birthright Palestine should not be seen as a response to birthright Israel. Jewish claims of nationality and self-determination must be clearly distinguished from the claims of Israeli Jews to nationality and self-determination as a matter of international law. Israel proclaimed her state on behalf of the Jewish people, a concept and definition that grants rights to and within the state on an extraterritorial basis. Israel enacted its citizenship law of 1950 to grant nationality to Jews only, repealing the Palestine citizenship law, as I said. The people entitled to national status in the Jewish state, defined under the Partition Resolution, General Assembly Resolution 181, included, and this is important, both Jews and Palestinians already residing in the territory, all of whom were to be granted equal rights under a constitution to be in force in both new states prior to UN recognition. The UN, including its treaty bodies and the International Court of Justice, has repeatedly called Jewish preferencing under Israeli citizenship, property, and other laws a violation of the UN Charter and human rights treaties. It's a violation of the very founding resolution 181. In other words, there's been no recognition of the Jewish people as a nationality concept that grants self-determination rights, nor is there legal consensus that Israel has a right to maintain a legal preferencing system that grants superior rights to Jews as against other citizens of the Israeli state. Jews coming from Arab states have parallel rights as refugees to Palestinian refugees, but these have nothing to do with each other. The first are claims against Israel, the second are claims against Arab states. They are individually held rights, individually to be satisfied against the wrongful state actor. They are neither rights that can be traded nor counterclaims by one state against another. The fact that the international mechanisms to implement these rights that exist for other refugees have failed for Palestinians does not negate the strength of the rights. Thus, Jews from Arab states have the right to return to their homes of origin, but Jews from all over the world do not have an internationally protected right to return to Israel, as they are not nationals of that territory in the international law sense. To the extent that a Birthright Palestine program reinforces Palestinian rights, whatever the link to citizenship within present-day Israel, it is consistent with the legal recognition given to Palestinians as a matter of international law. But to the extent that Birthright Palestine and Birthright Israel are seen as recognizing parallel Palestinian rights with Jews from all over the world, such symmetry is not supported from the point of view of international law. On my third point, granting Palestinians temporary visitation rights to Israel cannot be interpreted as implementing a right of return. A passport to visit or a visa to visit neither creates nor negates a right of return, whether such right is based on recognized Palestinian nationality or other legal grounds. The right to return exists independently through recognition under international law, whether through treaty or international custom, and not what civil society encourages or tolerates. Temporary visitation is not a substitute for the right of return either, nor a substitute for a host of related rights such as property restitution, compensation for losses, and restorative or retributive justice, to which Palestinians also have legitimate legal claims. In resolving refugee flows during and post-conflict, states and international agencies, particularly the United Nations High Commissioner for Refugees, implement repatriation programs coupled with property restitution, compensation programs, criminal tribunals, and truth and reconciliation programs. In many such programs, UNHCR promotes look-see trips for refugees to be able to go home for short periods, to assess the safety and viability of permanent return. At the same time, many refugees simply return to their homes on their own, outside of the auspices of an internationally organized repatriation program. Whether organized repatriation or independent return, these are simply forms of ultimately implementing a refugee's own voluntary choice of whether she or he wishes to return or not. The choice is the refugee's. The right is absolute. And the international community's obligation is to implement that choice once made. With Anne's paper in mind, then, there's no obstacle to UNRWA's assumption of the same kind of role that UNHCR assumes for other refugee groups in facilitating look-see trips for Palestinian refugees to be able to go home for short periods of time pending final resolution of the conflict. There's nothing in UNRWA's mandate, its area of operations, or its functions as a neutral humanitarian agency to prevent it facilitating organized trips for Palestinian refugees to visit homes, families, and properties in Israel. With Jinan's points in mind, such delegations could comprise subsequent generations of Palestinian refugees, and those with second or third state citizenship are obviously in the best position to obtain entry into Israel for such purpose. Let us then make a modest proposal that instituting a much broader Birthright Palestine program to include civil society and UNRWA would be a small step forward on the long road to return. But let me end with a more robust and infinitely superior proposal. Replace the notions of Birthright Israel and Birthright Palestine with a new nationality and citizenship law of Israel-Palestine. Such a law would confirm that all Palestinians who were recognized nationals of Palestine in 1924, both Arabs and Jews, and their descendants through either mother or father, and all Jews and Arabs who were habitually resident on the territory of Palestine at the passage of Resolution 181 are automatically nationals of Palestine. If on the territory, they will become citizens with full and equal rights. If not, they can be granted citizenship without arbitrary constraints in the state of Israel-Palestine. At the same time, people of all faiths can freely visit Israel-Palestine without arbitrary limitations for temporary periods in exercise of their own identity-based birthright to visit the Holy Land, however they characterize that sojourn. Thank you.
I'd like to thank all of our panelists and our moderator for those fantastic presentations. I think we all learned a lot. I'd like to open it up right now for Q&A. As you can see, there are mics on either side of the forum. And I'd like to remind you all to keep your questions to questions, that is, and then with a question mark. We are here to listen to the moderators, to the moderator and the panelists, and to learn from them. While also reminding ourselves that to try and give an opportunity to those who have not yet asked questions as well to ask questions. So I think we'll take 2 or 3 questions, and then we'll come around in the first round of questions, then we can come around for a second round of questions as needed. Right now it looks like there are 3 people lined up right there, so I think we can go through each. And please state your name, your affiliation if relevant, as well as who your question is primarily directed towards. Thank you.
Can you hear me?
Yes.
My name is John Spritzler. I live in Brighton, near here. I'm the editor of NewDemocracyWorld.org. My question is to the panelists. Would you not agree that the perfectly unchallengeable points that were made about international law supporting the right of return, coupled with the equally unchallengeable fact that the people with real power on this matter have completely ignored international law in denying the right of return, would you agree that the coupling of these 2 facts implies that international law is not really what determines what happens in the world, that people with real power use it when convenient and ignore it when convenient, and therefore, to get right of return, we need to build a mass movement in the world that, instead of relying on international law, relies on the power of numbers of real, good, decent people knowing what's right and fighting for it.
Okay. Okay, and then if we could take 2 more questions from that side.
Sure. Hello. My name is Austin Branyan. I don't have any affiliation of any sort. And my question is also for all three panelists, whoever chooses to answer it. About a month ago in New York, there was a group of Israeli officials and assorted American Zionists, chief among them Daniel Pipes, who had a meeting kind of counter to this conference, which is how to combat the right of return. And one of the things that was mentioned there is that Pipes and his crew want to try and introduce legislation in the Congress to prevent the United States from ever recognizing refugee status to those who were not actually kicked out of Palestine. So to remove it from descendants of refugees. And so my question is, how do you respond to that? And how does the Palestinian case of hereditary refugee status compare to other cases of refugees? Is there any precedent for that? And if so, how has that been dealt with?
Yes. I have a first question to Susan. The records related to the nationality law, passports or documents of 1924, 1925 are available where? Because this seems to be, I'm very ignorant about those documents or their archives or whatever, but they would seem in your argumentation a key element that would complement or support, any way precede the UNRWA records. I have a number of questions and remarks for Irfan. Well, I don't know if you were speaking as an UNRWA representative or you had a hat as a researcher or a militant. However, you will choose which hat, or maybe still another one. You began saying that UNRWA is a non-political body. I don't know if you were ironic or you were... I mean, UNRWA, as any humanitarian agency who might have an official non-political mandate, the activities of the agencies are highly political. I mean, who believes that UNRWA is apolitical? I think we have to do away with this definition, which is rhetoric, or which is juridically stated, but politically and sociologically ineffective. Okay. You said that UNCCP didn't do nothing. Don't you think that is not the fact that she didn't do nothing, but rather that she was not given the means, which makes a big difference? You then developed on three issues: protection, record, and representative nature. Concerning protection, I don't think it's just an academic debate. Can you give me a concrete example of how UNRWA has been exerting a protection mandate? The only one I know was during the first Intifada, when the refugee affairs officers became effective during Giacomelli period. And if you remember, at the beginning of the second Intifada, one of the first things that the IDF asked UNRWA to abstain to do was to replicate the refugee affairs officers. The rest is just a blah, blah, blah from the agency. And on that regard, I think that what would be interesting to analyze is rather the fact that the last two Commissioner General have been former HCR people. Karen Abu Zaid was the former Chief of Cabinet of the Commissioner General of HCR in Geneva, and Filippo took her post. And then both of them, they were Deputy Commissioner General of UNRWA. And if you look at the past 10 years...
So I think we have like 5 questions up right now. So could we...
But these are very important issues because we are talking about...
But I think we can present these conversations in individual panels. We don't have to take up the entire time because we have about 15 minutes for questions and we have a lot of people here.
The question is, what is behind the important inflow of HCR officers that are now heading most of the field offices as directors of UNRWA. And would it be an idea that UNRWA should disappear and being incorporated into the HCR? From a number of donors' point of view, this could make sense.
Okay, so I think
others, but
so I think we have about 6 questions now. So if you all want to try and take these.
Maybe I'll take the first one. I'm not sure. Is this working?
Is the mic? Can we get?
Hello? Okay. I'll just take the first one because I always get it. Law is irrelevant. Why are we talking law? But the interesting thing about refugee law is how relevant law really is, because what I was talking about is actually law in practice. So what one has to look at is, why is this law so strong elsewhere, and why is it so weak here? So taking the second point, shouldn't we just look to people power and forget about law? But people power without some kind of legal basis to justify the actions is also pretty useless. So law instructs us about what the relationship of justice to outcome of conflicts. And without some sort of an informative legal basis to provide a framework for moving forward, it's basically whatever anybody decides to do. That's not going to help us resolve this conflict. So law has, I would argue, from a practical point of view, law has these 2 very important attributes. One is, on the international level, law is practice, law is state practice. And then from the point of view of instructing civil society, law is the basis for moving forward.
Okay. In response to the question about Daniel Pipes, I think you asked, if I've got this right, about comparing the Palestinian refugees to other cases of refugees and responding to his criticism. I know he has a lot of criticisms of how Palestinian refugees are treated, but I think his main objection in this case, correct me if I'm wrong, is the inclusion of descendants, right? My response to that would be, it's actually a fallacy that's unique to the Palestinian case. It's particularly prominent in the Palestinian case because of the long-term nature of the exile. But when it comes to UNHCR, I mean, UNHCR with long-term refugee cases in Afghanistan and Central Africa also count descendants as refugees and also provide services to descendants. It's just that most other refugee cases are resolved more quickly than the Palestinian case, so the descendant issue doesn't arise in the same way. But this is really a myth that's being perpetuated by people with a particular political agenda, that it's something unique to Palestinian refugees. In response to Professor Bocco's questions, first of all, I apologize if I gave the impression that I think UNRWA is a non-political body. I certainly don't think UNRWA is a non-political body. I actually dedicated my thesis to arguing that it's not a non-political body. The point I was making is that it's officially defines itself as a non-political body. We can have all kinds of discussions about whether or not that's correct, but that wasn't really the focus. That's not really the focus here today. My point was, because it defines itself as a non-political body and because it's required by its mandate to be a non-political body, how can we involve it in a way that's not going to throw up all these other debates, that's going to keep it focused on the humanitarian work that it's supposed to be required to do? That was my point. Sorry?
The point would be that others would believe that it's really not political to include it.
Right.
So Israel will never accept it.
But I don't think we can determine this on the basis of what Israel is going to accept or what Israel's not going to accept. Israel doesn't want to accept return. That's the whole point of this conference, right? Yes. With regard to the point about UNCCP, yes, you're probably right. It wasn't given the means to do anything. I mean, again, my focus wasn't really on deconstructing UNCCP. So again, I apologize if I was unfairly harsh on UNCCP. I mean, the fact of the matter is it's been inactive, and we can debate the reasons for that. The third question was about UNRWA, concrete examples of UNRWA providing protection. There's all kinds of cases of UNRWA intervening with the Israeli occupying forces, particularly after 1967. The one that springs to my mind is a case of Israeli forces going into a Mari refugee camp near Ramallah and demolishing shelters, and UNRWA intervening to get this practice halted. That's one example that comes into my mind, but we can have a further discussion afterwards. I'm sure everyone doesn't want to listen to me list endless examples. And the final question was about whether UNRWA should be incorporated into UNHCR, right? No? Okay.
Actually, I forgot to answer Ricardo's first question. The 1925 Citizenship Order was an order in the British Mandate period. That law is available. I think about 60,000 or more Palestinians actually received passports under the Citizenship Order as Palestine citizens. So those records are also available in, you can look at the mandate period records. There's one scholar who has done, I think, the most work on this, and we can talk about that paper in terms of the nationality law. But yes, this has been forgotten, but Palestinian citizenship, nationality goes back now a long time.
Mm-hmm.
I think most of the questions have been answered, but just maybe to reiterate, Anne, about sort of trying to limit the meaning of who a refugee is and and who has sort of the right to return. I think in general, like for Palestinians, it's always been trying to be limited anyway as well. Like even just with UNRWA's definition, like it's for purposes of aid. Like that's a very limited definition. Those who lost their homes and means of livelihood. That's who UNRWA regards as a refugee for purposes of aid. And so I think this is just one of the other ways of just trying to get the Palestinians to relinquish their right of return or to prevent them from, returning. But I don't think even international it has any basis, because as Anne was saying, like in other refugee situations, descendants are also considered refugees. So.
So unfortunately, we don't have time for any more questions, but I invite those with questions or responses or other kinds of feedback to do so when in the coffee break that's following or at lunch. So if you could all join me in giving our panelists another round of applause.